this sort of emphasis on greater constitutionality because of the different forms of international rights protection which apply there, has pointed the way to us and is sort of lighthouse in the sorts of challenges which can be brought. But it also has a very practical impact. We are never going to have Windsor framework provisions available to us in England or in Great Britain generally, but the consequences of it applying in Northern Ireland are profound for the overall suite of legislation under the Nationality and Borders Act, the Illegal Migration Act, and the Safety of Rwanda Act. Because if those laws are not good in Northern Ireland, then asylum seekers, in principle, there are no borders between Great Britain and Northern Ireland, obviously, could move there. You can't restrict movement. One of the things that is very politically sensitive is having border controls, physical border controls between Great Britain and Northern Ireland, if you like, on the ferry route from Stranraer to Larne, and you can't do that. And so you can, of course, put a condition of residence on an asylum seeker, the equivalent of what might be one under Section 3 of the 71 Immigration Act, or under Schedule 2 if you're on immigration, or immigration ban under the 2016 Act. But that doesn't stop you actually physically moving, right, once you're in Northern Ireland. And so that makes it very, very difficult to see how either the Illegal Migration Act regime or the Safety of Rwanda Act can be universally applied to all the asylum seekers who are subject to it. It seriously weakens that regime because, in fact, in practical terms, regardless of what advice people receive, and in practical terms, if people know that in Northern Ireland these provisions are unlawful, they're likely to want to go there if they're in Great Britain. And there is no real answer to that. And it's striking that the general election was announced after the Northern Ireland judgment, because if there's one thing which prejudices the government's plans to transfer people to Rwanda this year, that's happened in 2024, it's this judgment. And it's because of the extraordinary difficulties it places in the government's path in enforcing UK-wide legislation in one part of the United Kingdom. Thanks very much.
Well, thank you very much, Adrian. That's absolutely fantastic to have gone through that judgment and dissected the reasoning and, most importantly, the consequences. So when we get to those conclusions, it does look like it's a very hard-edged response, which is actually the IMA is unlawful in Northern Ireland, and query what should the response of lawyers in the UK representing asylum seekers in the rest of the UK be? And I think that subject to any appeal, obviously, do we have a timescale for the appeal?
As far as I know.
So we'll have to kind of watch this space. But I mean, domestically, you've got a court who've looked at the IMA provisions and reached the conclusions in relation to the incompatibility under the HRA. And so, a far-reaching strategy could be that in the rest of the UK, somebody tried to launch a similar type of claim in anticipation of commencement. Now, of course, we don't have any, obviously that's not necessarily, it's not required to be commenced. We have tended to use that approach of waiting for commencement, but as Adrian has just identified, that's not necessary. And of course, that case is brought by the Northern Ireland Human Rights Commission to effectively test the lawfulness of the IMA with a very concrete outcome. So I do think that well, let's wait and see what the what the Court of Appeal judgment comes out with, and what the timetable of that would be. But in the meantime, of course, domestically in the rest of the UK, we've got a varying pieces of litigation going on in relation to Rwanda, and I just wanted to update people on that, because I think probably that's one reason why many people have come to this seminar or webinar, because every day there seems to be a change of policy in relation to implementation and actual removal, as David was indicating in his presentation. So currently there are 3 significant pieces of litigation in the High Court, and there are various others individual claims, as we understand it, in the upper tribunal. So yesterday, I think I'm right in saying that the High Court, Mr. Justice Chamberlain, who's the lead judge in the Administrative Court, heard a directions hearing in the case of SM and Asylum Aid. So 2 cases, one brought by Asylum Aid, the NGO, and separately an individual claim, also represented by the same legal team, I think, but on their individual facts. So the Asylum Aid sort of generic claim, if I can put it in those terms, is challenging the lawfulness of the Rwanda policy, the safety of Rwanda, the policy implementing the legislation that we've just been through, and in particular the lawfulness of Section 4.2, which doesn't permit the decision makers to consider the questions David's identified of whether the Republic of Rwanda will or may remove or send the person in question to another state in contravention of any of its international obligations, in particular the Refugee Convention. So that plus the ouster question is what is before the court in Asylum Aid. But as I read Mr. Justice Chamberlain's directions in that case, which he set the case down for hearing, for 4-day hearing in July of this year, the 8th of July, I should say. July is obviously a very contentious month. He's set down for the 8th of July and following in relation to the SM claim. He refused interim relief on the basis he said it wasn't required because the government indicated. But I think now, for the first time in a concrete date, we've had a series of moving parts on this. But on Monday, yesterday, the government said that they weren't going to have any enforced removals to Rwanda until the 24th of July. So I may be paraphrasing, need to be really clear about what language was used. I think I understand that was flights, possibly charter flights, but we do need to be really clear about what language was used in relation to those undertakings made in that case. And indeed, Mr. Justice Chamberlain has also identified that there may be other cases. He says in his judgment that in the unusual context of these claims and the need for relatively quick resolution, he's going to hear it as a rolled up hearing. And also it may be appropriate for other claims to seek to be joined with the SM claim. So that's also something to keep an eye on. And it's also, and that is being heard this week, is the FDA claim. So the FDA are a trade union representing many civil servants who have brought and had already brought separate proceedings in relation to whether they're being asked to breach their code in relation to a query about whether they were breaching international law, including a direction, if such a direction were made, that they would not necessarily uphold the Rule 39 injunction issued in Strasbourg. So that was again a sort of anticipatory claim, and it was either going to go slow or fast depending on when removals were proposed. When the claim was issued, removals were originally proposed to be, I think it was said to be in July, then it was actually said in other cases it might have been as early as the 24th of June. Then the Prime Minister made various statements which suggested that it was sort of early July and it wasn't clear. And again, and importantly, in that case, Mr. Justice Chamberlain made an order of the court's own motion to say, we want to know, the court wants to know in terms of trying to timetable this case when the removals are intended to be commenced. And so, again, it was said in language, again, needs to be examined quite carefully, that it wasn't the government's intention to commence enforced removals before the 4th of July. So, and now we've had the 24th stated in the SM case. So what that means, so for those people who are attending this webinar who are practically advising and representing individuals, many people were taken into detention from March onwards, as I understand it. Certainly my clients have been detained from that period of time originally. They were served with notices of intent, and again, just reminding ourselves that in the SM case, that challenge is not a challenge to the decision to remove him to Rwanda, but rather to the notice of intent. And part of the challenge there is that refusing to admit his asylum claim for, after 2 years after it was made was contrary to the Secretary of State's policy, immigration rules, and or his Article 8 ECHR rights, and that there needs and then some practical procedural arguments about extensions of time that were required to respond effectively to the notice of intent, and also in relation to the mechanism and working of the Safety of Rwanda policy, which is now version 2, following the earlier asylum aid pre-action correspondence. And finally, in relation to Section 4.2 of the Safety of Rwanda Act. So that's the asylum aid, the SM case. A lot of those people who were detained earlier this year have been granted bail, we understand, by many tribunal judges, and many people in chambers and around other solicitors and firms have been successful in granting bail. I have to say I haven't, or achieving bail. I'm not aware of anyone who's been refused bail, but please do let us know if anyone has been refused bail. Importantly, again, I don't need to identify whether people are still being detained, because there'll be a question there about whether their removal can be properly said to be imminent. But obviously that detention and practice of detention has created huge anxiety for a class of people who may never be removed to Rwanda, and even if the policy were even going to carry on, which which is now a sort of party political issue, that even if they were going to carry on with removals to Rwanda, in theory, it's not possible to identify on one level whether all of the people who've been served notices of intent could ever be removed to Rwanda. Last time in Rwanda, the first round of litigation, 20,000 notices were sent out. But as we heard from David, that there's only sort of 300 or so places in Rwanda for people to actually be removed. So there is a live question mark about the lawfulness of a policy that applies to a whole class of people but can't actually be affected to many, if not most, of those individuals. And then what are the criteria by which the people to whom it might apply, what are the criteria which are applied to those who are finally selected? And is it almost, as it seemed to happen last time, a sort of survival of the claims that weren't able to get out in time by various methods of representations, pre-action letters, and so on, which happened, I think, by the time we dealt with Rwanda 1 and the last cohort of people who were on the plane, I think down to about 8, including, as I was reminded, a couple of people who didn't have legal representation, who would otherwise have been removed to Rwanda, but for the Rule 39 and the ensuing domestic situation in June of 2022. So those are all matters for those who are advising to be aware of, in terms of if you have clients who are in detention and the Home Office are not taking a decision to release people pending, they could have done, and as far as I understand it, I haven't come across any evidence of any solicitor saying that people are being spontaneously released. So what that means really is that you have to apply for bail, and there may have the inadvertent consequence from the government's point of view of creating potential unlawful detention claims for people who are in that position, particularly given the lack of clarity on the guidance as to whether persons were going to be removed, might have been removed, when the removal is going to be, 24th of June, 4th of July, 24th of July. I mean, all of those matters are relevant to the question of whether their removal was going to be imminent. So that's one of the first things to observe. And another thing to observe, actually, which I meant to say when we were dealing with the treaty, of course, is that the Secretary of State has expanded the ambit of those who are subject to the treaty, who might be removed under this treaty, to include failed asylum seekers. Now, I say that because it's important to remember that the government's it relies now on the exchange of letters, which that's not in the treaty. They're sort of exchange of letters, a little bit like note verbal, but the 10th of May exchange of letters where they identified that it was the definition or interpretation of the term relocated individual, which I referred you to in the opening part of this webinar, includes by their mutual stated understanding that persons who are failed asylum seekers, even though for those who have received notices within that, who were in that group, they may have been people who came here long before the MEDP was even in contemplation, long before the treaty was set up, and long before the Safety of Rwanda Act, so, which, as David set out in his presentation, was obviously has to intersect directly with those treaty obligations. So there is a concern there as to, and a potential legal challenge there, of course, as to the status of those letters and what those, whether it could properly be said that people who've been here for sort of 6, 7, possibly more years, who've never been removed or probably are not likely to be removable through documentation or other issues, whether they come within the ambit of statutory scheme and the treaty. So I flagged that as another issue in relation to where we are in terms of issues going forwards. But I think where we really are now, I think, is that we're in a slight stalemate, notwithstanding that these cases of SM and others are going forwards, and FDA is going to be heard this week, Thursday. And I just observed again there, it was open to the government to say they didn't want that case to go ahead so quickly and to seek a sort of slightly slower timescale, but they themselves didn't invite that. So actually, the government is inviting the court to determine the question, which I think is going to be heard by Mr. Justice Chamberlain. And that may or may not feed into other legal, political intersection in relation to the ECHR itself. It's hard to know. I just wanted to, then we have a little bit, so those are my observations, final observations in terms of what we've heard today, and hopefully updating people. I'm very happy to take any questions and also any other thoughts or observations that David or Adrian have. There is one question first already online, which is what grounds were bail granted recently in the case of detainees who were to be removed to Rwanda?
I think it's primarily on the basis there's no imminent prospect of removal, I think. And also, I think for the vast majority, as I understand it, of those that were subject to this process, we're very rarely dealing with individuals that have, a history of offending, present as a risk of harm. And most or many were detained whilst reporting. And so, the risk of them, or them being able to be characterised as absconding risk, is compromised on that basis too. So I think generally, save in instances where there are question marks as to the accommodation into which people can be released, because obviously mass accommodation will be lost for those that have been detained over an extended period of time. So that bail in principle is considered. In some of those instances, I understand some tribunals have been more cautious, but generally it seems to be released based on there being no prospect of removal within a reasonable time. And although I understand it that the presenting officers are still fighting these cases, as Somali said, there is no blanket decision to release people. It is necessary to fight your corner still, which seems ludicrous. And doubtless, as Somali also suggested, is going to lead to unlawful detention claims in due course.
Yes, I mean, what I understand from the bail summaries, and we've seen a few, they're still saying there's an intention to remove. And even if the effecting removal isn't going to be till the 24th of July, the government is saying, well, we want to detain people so that we can effect removal. And no court is entitled to second guess the outcome of an election. So, of course, this is the law as it is enforced today. And it will be, and that may, to what extent and how that's reviewed after the election result and if there were a change of government, that's again not one that the court can really second guess. It's not entitled to do that. So we are, those people will have to. I think that's possibly why the government changed their position on the dates of the removal, because it was causing quite a difficult position in relation to the court and incurring significant costs in relation to litigation. I can see the FDA case, why they wanted to do that case, because it's got a freestanding issues, notwithstanding that it was issued in the context of the Rwanda litigation, sorry, the Rwanda legislation, but the principles are freestanding. But one of the difficulties that might come is in relation to the SM policy challenge, which is going to be heard, as they on the 8th, as things stand anyway, on the week of the 8th of July, and that won't just be SM, it may well be others. And maybe it may also be that the court wants to issue a judgment as to the legality of the policy. Otherwise, why would they want to hear it? And also, why would the government not kick that can down the road a little bit further? So if they want to commence removals by the 24th of July, they're going to have to actually go through the motions, importantly, of having those cases heard and determined, so that if there are to be removals, then they could, they will take all so that the litigation, so that the removals can take place, if they are going to take place, once the legal questions have been first resolved, which may, of course, mean that there are no removals. We can't, again, second guess that either. Adrian. Oh, sorry, just another question there. In the recent bail grants, the question is, did the Home Office have specific flight dates? Well, we've heard, so we're in communication, certainly in chambers, with our colleagues who are doing bail applications, and really putting themselves, there's so many cases and there's so many, there's a real pressure on all of our colleagues to get these bail cases done. But last week, as recently as last week, I think we saw dates that said 24th of June. Yeah. Then they moved to 4th of July, up to the 4th of July. And then finally, well, we'll see what this week's bail.
Yeah,
summary.
They were saying the 24th of June that week, but which would of course be before the election. And so there was no reason in principle why that couldn't have been a removal week, apart from the litigation and the asylum aid case and the pressures that created. It's just that they didn't actually serve any decision to remove. These were notices of intent upon which people were being detained. And so if someone was to be removed, they would have had to take steps, which they hadn't taken. And so bail was relatively straightforward to get, because there was no actual imminent removal and no prospect of it, because none of the procedural steps to make removal real had been taken.
Yeah. I think one bail grant which was circulated, it was recognised by the tribunal that, as Adrian's intimated, we're only at this stage dealing with a notice of potential liability to inadmissibility process, from which there would doubtless be a legal challenge and a process that would have to be gone through. This is all in the context of an earliest release removal date at that stage. I think this was several weeks ago, looking in July, and so that's obviously constantly shifting. But I have to say that from my experience, generally, judges tend to be fairly sceptical in the first tier tribunal about sudden indications of impetus from the Home Office and an offering of a date to removal. And so it's pretty much the usual game plan from the Home Office, I think, of throwing out dates which they're unlikely ever to be able to meet, in the hope that it will be sufficient to distract a judge from making what should be an obvious grant. It doesn't seem to be working, fortunately.
I think in terms of strategy, again, for anyone who's here on this webinar thinking, what should I do? I don't suggest in it for anyone that we should downing tools and saying we don't need to make representations in response to NOIs. We need to be preparing all of that evidence and those cases and those representations, because we have the government is the government. We have the law. They've said they're going to implement it, even though we're in this pre-election period. It doesn't mean that we shouldn't be carrying on representing our clients, getting them out of detention. And it's but if they have representations to be made in relation to responding to notices of intent and why their claims should not be held to be inadmissible under the regime that's being applied to them, including delay, as like the SM case, including I've been waiting for as I made the representations 2 years ago and you haven't determined my claim, or you haven't admitted my claim, let alone determined it. So those are all properly well-made, good arguments to advance, and that I can't see any reason that can properly be said not to just to carry on with that work. I mean, as the Northern Ireland case identifies, and even if some work is anticipatory, it's important can't wait until the situation is upon us and then react to it. If you know a notice of intent is exactly what it says. It is an intention to remove in a particular context. So for all of those reasons, I think we absolutely should carry on. Of course, I'm sure everybody is, but just in terms of trying to prioritize work or trying to identify issues around funding, for example, I think it's absolutely key that people apply for funding to represent the clients they have who are faced with those notices and not assume any kind of outcome or consequence as a result of the potential election result. So
I agree entirely with what Sanai said. I mean, I can see how it must be difficult for people to motivate themselves to persist with responding to notices of intent, notice of inadmissibility rather, given all the other pressures doubtless that you're working under. But what we've seen recently, where requests for more time have been advanced on the basis of reasonable and sensible evidence gathering exercises, which are justified and substantiated with timetables and so forth, is that instead of the response that was being obtained in the early stage of this exercise, where they were simply extending time by a couple of days or maybe a week if you were lucky, they're now responding, particularly to pre-action letters, complaining about those kind of replies by saying, well, we're going to pause the process and we'll get back to you in 7 days as to whether or not we will give you more time. So it's a curious arrangement. It seems that, you know, we can push them by following through. We can push them into a position where not only are we setting up our cases to be stronger in front of a judge when seeking bail, because we're advancing compelling reasons as to why the case is not going to be ready anytime soon, or why a case should be taken out of the admissibility process, and why evidence gathering is necessary. But we're also getting responses from the government acknowledging that they're not in a position to even respond to a request for more time at the moment, so, which is obviously beneficial.
And one of the questions online was whether we've seen a lot of notices of intent, and we've seen a fair number. And I think importantly, when you have those notices, and this goes back to David's presentation, of course, you still can advance individual circumstances. So even if you weren't doing anything else, you'd be looking at gathering evidence about individual circumstances. And if you need more time, so that's commonly medical evidence and so on, then commonly you would need an extension of time. And I think this is very concerning to note that they are not necessarily responding to requests for extensions of time. And when we did our last webinar session around how to respond, what was identified was that the government would say, we're not going to give you a response, but we may refuse the extension of time at the same time as we make the decision. So that may or may not be likely to happen now, but that's certainly something to keep an eye on. And the thing, actually, one of the things I meant to mention right at the outset, which is why I started with AAA, even though we all think we know what it says, is more importantly for what it didn't say, because AAA in the Supreme Court never looked at conditions in Rwanda in terms of conditions for asylum seekers and refugees. And there may well be reasons why you want to advance a claim about what would happen to your individual if they were removed to Rwanda, not about their particular mental health, or as an example, but in the circumstances or their ability to or not to express their political views. And that was something that was highlighted in the very opening observations in the judgment. But that point, which we had permission to appeal on in the Supreme Court, was never determined. So I just leave that as being still what I would describe as an open question. So I think actually, hopefully that's probably all we've got time for in relation to. There's another quick question. Sorry, I'll just quickly try and deal with these last two questions. With somebody, Rainbow Immigration Legal Services, I volunteer for a charity that has over 100 asylum seekers without representation. We're having difficulty finding solicitors with legal aid capacity. How can we help these stressed and worried people? Well, I think for the moment, I mean, it is obviously a really stressful time. As David was talking about, people being detained and now being released and being worried about what was going to happen. And it's been a most intense time for those who are potentially subject to this regime. I'm really concerned if this, if this was the 23rd of July or the 20th of July post-election, when we still have removals in contemplation, I think we really need to be able to find representatives. If anyone was going to be removed, then unfortunately or otherwise, they'd be in detention and therefore in some ways have access to someone to represent them. But it may, as we know, be coming a bit late in the day in terms of evidence gathering. But the test, hopefully what you will also see is these test cases, asylum aid and others, will bring with it some sort of principles that have a wider application. But I mean, we're very grateful, of course, to everybody who even is able to be the intermediary, if you like, for those very vulnerable people who can't get legal aid in the legal aid deserts that we're all aware of. Now, the quick question, which is from Southwark Law Centre about responding to NOIs. What about pursuing PAPs, pre-action letters and judicial reviews, particularly with those who are part of the pre-Borders Act cohort? I mean, is it potentially risky? I agree, to draw attention to those people who are in that cohort. And I think there is if we weren't in this pre-election period and we know that there may be a change of, or at least we're conscious that there might be a change of policy, I think there is, I always thought there was a risk in saying, determine my claim now, I've been here for 2 years and it's, it's unlawful not to determine my claim. On the other hand, the cases that have gone forwards are ones with very particular strong facts. I think you'd have to evaluate the factual context really carefully. That I have been quite concerned about that.
SM ground one, isn't it? That there's
delay
effectively, yes. That it's been 2 years or more since the claim was put in the pending pile for an admissibility consideration.
Yeah, I mean, I think it is potentially risky unless you've, if you're going to take that, either because your client really wants you to press that and you give them the sort of options and identify the risks, or because their case is so compelling and strong that there are factors which are likely to keep them here even under 4.2 of the Rwanda Act, Safety of Rwanda Act. So in answer to the question, is it better if the asylum case is processed quickly or delayed? It's very difficult to answer that generically unless you have the detailed facts. So I would say that because things are moving very fast at the moment, unless you have a really strong case, I think probably I would at this point in time say I would wait and see. Would you?
I think some of them are going to go forward anyway, but they must be among the strongest, actually.
Yeah. Anyway, I think that's probably all we've got time for now. So thank you very much for everyone who's come to this webinar. And the situation is going so fast that you have to keep reading any blogs and other resources online. But I hope that was useful for those people who are here. And of course, if you do need any other advice, of course, and you can contact and you have a client who you're representing, then the usual mechanisms of getting in touch with barristers at Garden Court is always available to you, of course. So thank you very much. That's good luck. We'll see what happens next. Thank you.